Good afternoon, Chief Justice. Good
How are
afternoon,
you?
Commissioners.
How are you?
I'm fine, thank you. I'm well, thank you.
Okay. You want to ask after my health?
Sorry, I missed that.
Well, in African culture, you exchange these cordialities. You are
Yes,
supposed to ask me
Yes. Chief Justice,
in
how
return.
Shem, Chief Justice, how are you this afternoon?
Thank you. It's been a long day, but surviving.
Shem,
Thanks
yeah,
for asking.
All right. Thank you for the prompt.
You're an attorney of many years, currently a director in Kabela Huntley Attorneys
That's correct, Chief Justice.
since 2005.
That's correct.
And for about 10 years before that, you were with Chidel, Thompson and Hayson,
Yes, that's correct.
where you started as a candidate attorney and worked your way up to senior associate.
Yes, that's so.
Right. You started out as a teacher.
Started out as a?
Teacher.
Yes, I did. I qualified in education, and I worked in an adult basic education NGO for about 8 years, and then I moved over to law.
Why did you change careers, if I may ask?
Yeah, the reason I did was adult basic education is unfortunately pretty much on the margins of the education sector. And I wanted to, explore other professional possibilities. And I think also around that time, which would have been early 1990s, there had been a certain expectation that there might be a large-scale, a mass literacy campaign post-1994, but in fact, the decision of the government was rather to invest in primary education, and quite frankly, I supported that. So I had a sense that my time in adult basic education was really coming to an end, I started to study for an LLB, which I did through UNISA. So I changed careers. But some of the basic principles of sort of redress and transformation in both kind of sectors broadly, philosophically, would be similar.
In addition to this LLB, you have 3 other academic qualifications, three, the BA, honors, and diploma in education that would have allowed you to work as a teacher.
Yes, that is so, yes.
And an LLM?
Yes.
In what area of the law?
In labour law. In labour law. I did that in 2009 at WITS, part-time.
All right. What kind of work do you do, mostly? Asking the obvious question.
Yeah, in my practice, it's quite all-encompassing in relation to labour law. I chair disciplinary inquiries. I represent clients in the CCMA. I also represent clients in the labour court, usually on reviews. I write HR policies. So really, I advise on strikes, collective issues. Basically, the full gamut in a way of what you would expect in a labour law practice. That's what I do, and obviously I train my juniors, my candidate attorneys, my associates. I play a role in the firm. Managing the firm and leading the firm. So I have a busy day.
Right. You've acted in the Labour Court intermittently since 2015. 2015, 2019, 2023, and last year?
Chief Justice, that's correct. All of those dates are correct, yes.
For a month per stint?
Yeah, so at the end of 2023, it was for a month, and then I acted for the full term in 2024, the full first term of 2024. Yeah.
So in all, you've acted for 4 months?
About 4.5 months, yes.
Which seems to be a concern for some of the professional bodies. What do you want to say about that, if anything?
Yeah, I've read the concern from the Black Lawyers Association, the sense that 4.5 months is not sufficient experience. And I appreciate that point, because I think the longer that one has experience acting, obviously the deeper your knowledge of how the processes work, etc., etc. But I really had a very rich experience as an acting judge, and I went back over all my various judgments, and I categorized approximately 16 different types of matters that I had presided over. Obviously, there were reviews, there were trials, there were contempt applications. I gave judgments ex tempore, restraint of trade issues, etc., etc. So, contractual disputes. So, during my time, I feel that I had a rich experience of the kind of disputes which would come before me as a permanent judge. So I do take the point. I appreciate the point. I do feel that I would be, if there was a novel issue that came before me, Chief Justice, I'm not a legal practitioner who busks. I'm just not. I make sure I'll have a look at the rules, I'll have a look at the case law, and I'll get on top of it. So I hear the concern, but I do feel that I would be able to competently judge the matters that came before me.
You have written judgments during your acting stints.
Chief Justice, sorry, I missed that.
You have written judgments.
Yes, I have.
During these acting stints, and you list 3 as being reported.
Yes, in fact there are 4, but there were 3 that came out of my term, in my first term in 2024. Yes, so there've been 4 reported judgments. The 3 most recent came out of the experience of acting for a term. Yes.
How many would you say you've written in all?
In all, okay, only 4 reported judgments, but in all, Chief Justice, probably, really over that time, probably about 40 or 50.
Were you able to deliver them within reasonable time?
Yes, Chief Justice, I got them all out. I'm very conscious of the 3-month rule. So I made sure that, yes, all my judgments came out within that time period. I have no outstanding judgments.
You've written articles in labor law which have been published. I count a few.
Yes, I have.
So writing is not an alien practice to you?
Maybe it's the teaching background, I'm not sure. But I do like to write. I do like to clarify issues if there are new issues in law. And usually what happens, Chief Justice, is I might be faced with a novel sort of legal point in my practice, and I do a whole lot of research, and maybe I'm drafting heads of argument, and what I realize is actually that not with too much work, you can really take some of the sort of affidavits or basically opinions that you've been drafting, and you have a look at what the requirements are of various law journals, and it doesn't take too much work actually to take the same sort of substantive body of your writing and just convert it into an article, which could be in the ILJ, it could be in contemporary labor law, it could be South African Labor Bulletin. So really, I would have a look at my audience, I would look at the audience and the readership, and then think, well, would this particular opinion, with a little bit of adaptation, could it be published? And so, yes, I have, and I've also started to write articles, for example, in the Sunday Times, opinion pieces, just to get to a wider audience. And labor law impacts on so many relationships. The employment relationship. So I think it has a wider sort of interest span, if I can describe it like that. So yes, I do write.
All right. Would you tell us just briefly what happened in 2019 concerning the matter you disclosed in your questionnaire, which led to a director in your firm being struck off the roll and the rest being mulcted with fines?
Yeah. Gosh, Chief Justice, that was...
And if that should be a consideration at all for us as we ponder, when we do ponder your eligibility for appointment.
Yeah. Thank you, Chief Justice. It was obviously an issue that I knew I would have to properly address in this forum. Basically, what happened was we had an aberrant director at our law firm who stole trust funds. He stole initially approximately 17 million from one client. The client came to the leadership in the firm and basically said, look, there's a problem. One of your directors has been stealing out of the trust fund. What he said was, I'm going to give this person an opportunity to recover the funds because it was a lot of money. And the aberrant director managed to recover about another 6 million. But essentially, at the end of the day, Chief Justice, we had a trust deficit of approximately 11 million rand. That was a lot of money. We reported the matter to the Law Society, and the Law Society came through to our offices, and they did a complete audit of our financial affairs, and they confirmed that there was a trust deficit of 11 million rand. The aberrant director obviously left the firm. He was subsequently struck off the roll. The Law Society then charged all the directors, there were 5 directors, and I was one of them, charged the directors with misconduct for failing to properly supervise our trust account. And we pleaded guilty to the charges. We sat before a disciplinary in front of the Law Society. We pleaded guilty. And we were fined certain amounts. I mean, if anyone is interested, I was fined 100,000 rand. I had to pay 50,000 rand, and that was the other 50,000 was suspended over 3 years. The other thing we did was that we then took out a loan from the bank, and we have paid off. So we took out a loan to cover the deficit in the trust account. And the deficit was covered, but we've had to pay back that loan. That's part of the punishment. That's what we had to do to make good on our negligence. And obviously we set in motion certain processes in the law firm where we paid far greater attention to the trust fund and the transactions between that were happening. made sure that we were FICA compliant. So I would like to submit to the commissioners here and to yourself that it is something that I've learned from. I feel I've paid the price, and that to the extent there were transgressions from our side, that the nature of the transgressions were negligence. They weren't dishonesty. We weren't dishonest. And the Law Society has continued to issue Fidelity Fund certificates to all our directors every year. There was never 1 year in which the Law Society felt that we were not fit and proper persons to be in the legal profession. It was a deeply regrettable time of my life. I hope I've provided a decent synopsis for you to assess the situation.
Thank you, Ms. Norton. JP Mlehle.
Thank you, Chief Justice. Good afternoon, Ms. Norton.
Good afternoon, Judge President. How are you?
I'm fine, thank you, sir.
Good.
I see in answering the question of your involvement in the labor matters, particularly in relation to the labor court, you say you occasionally appear in the labor court. And that seems to be supported by the number of cases you've listed under paragraph 6.4 of the form, where you ask reported cases in which you appeared as an instructing attorney. So your weight of work in the matters related to the labor court isn't that high. And you do say that most of your cases you litigate in the CCMA.
Yes.
Is that correct?
Judge President, that is correct. Let me clarify. Because it was also a concern raised by the Black Lawyers Association, and I went through my cases over the last 2 years. I just took 2 years, have a look at my record, and I appeared 10 times. So Judge President, I think when I listed those particular cases, I think those were in relation to reported cases where I've instructed counsel.
Okay.
They weren't, I certainly haven't only appeared 5 times over 20 years in the labor court, but I appear approximately every 2 months or so, and I did provide a schedule to my response to the BLA, really setting out the cases where I have personally appeared, and most of the time, Judge President, when I do appear in the labor court, I appear without counsel. I do it myself. And as I say, over the last 2 years, there were 10 occasions. So I think that's a reasonable, probably a reasonable average, approximately 5 cases a year.
Okay. And the nature of matters that you handle when you appear before the labor court?
Judge President, they're largely reviews, pretty much reviews, if I had to kind of categorize the nature of the matters before me, they would mainly be reviews,
Okay.
either initiating or defending.
Okay. And have you appeared before the Labor Appeal Court?
Judge President, I have, yes. I did. In 2023, it was Prasa versus Mahubi. It is a reported judgment. Yes, I have appeared in the LAC.
And did it go your way or the other way?
Unfortunately.
It went
No. Unfortunately, it didn't go my way.
Okay.
It had gone my way in the CCMA and the Labour Court, but when it got to the LAC, no, it didn't go my way.
Okay. Thank you. And tell me, in the manual, we mentioned this issue about attending tea. What do you find as a value in attending the judge's tea?
Gosh, that is one question I could never have anticipated. appreciated. But let me say, the value of attending judges' tea is you get to meet your colleagues and you hear about their matter. And if you have a matter that is troubling you or you need a little bit of advice, colleagues are very, very generous, actually, with their knowledge and their experience. As often as I could, I would attend the judges' tea.
And you seem not to have missed any one of them, at least for the time that I've always been in the table.
Yeah, no, I did attend.
Okay, thanks. And,
Yes.
and now in terms, and the Chief Justice put this to you about your acting stint. It's quite a short stint, isn't it?
Judge President, you know, 4.5 months, I would have liked more. But I took the opportunities when the opportunities presented themselves. I've also, this is not as an acting position, but I've also spent quite a lot of time at the Labour Court in the pro bono clinic. And at times I'm asked to, go to court and represent an indigent employee. But yes, look, I can't take it much further. It's 4.5 months, and
And
that's what it is.
In that period, did you do any urgent application and unopposed motion?
Yes. Oh, yeah. No, I did unopposed.
How did you find those courts?
Look, let me talk about the unopposed court. I found the volume. I must say, I found the volume of matters that I had to apply my mind to quite onerous, but I did manage. In the unopposed role, well, certainly when I was acting, there would be sometimes 30, 35 cases. So yes, I found the volume quite onerous, but I managed. I got through it. I obviously had to prepare. I think Monday is the day of preparation for judges, and I just read, prepare draft orders, etc. Urgent application, yes, I did have an experience of an urgent application in relation to an employee who wanted to expedite execution, and the employer brought an application, an urgent application to stay enforcement. And that was one of the matters that I heard on the urgent roll.
But you didn't do a full agent court role?
No, I didn't.
Oh, you didn't?
I didn't, Judge President, I didn't.
So I was going to ask you about whether you've ever used the court online system.
Yes. Judge President, we, obviously as a firm, we up, and my colleagues who are doing work in the civil courts, they're up and running. But I'm afraid to say that we have tried to register, and maybe this is not necessarily for this forum, but we keep getting a response that says something like your LPC number is irregular or whatever, and actually the LPC number is on the website. So we are following up, and I'm very aware, and I want to applaud you, Judge President. I do, because the Labour Court is going online, and I saw that there were new directives issued, I think maybe yesterday, for the 14th of April. And I think this is going to be a very transformative process in the Labour Court, that our pleadings will be served and filed online, and there's an opportunity to run matters online, and I think it will be of benefit also, because there will be an orderly way in which one can manage the pleadings. I must say, one of my challenges when I was acting is that you could get a couple of boxes in your chambers with a range of files in all sorts of condition, and you'd have to obviously make your way through them. But I do think that the court online is really the way in which to go. It's going to streamline processes, and I think it's absolutely the way to go. I'll just have to work a little bit harder with the LPC to make sure we can register. We have been trying.
But that issue you don't have to worry about. The technical people will help you.
Okay,
as
thank
soon
you.
as you contact the help desk, they'll sort you in less than 20 minutes, I can assure you.
Good to hear. Thank you,
Okay.
Judge President.
The other question I wanted to ask you relates to how did you find the acting stint? Is it pressurizing? Is it easy? Were there fewer files given to you? Did it impact on your social life?
I'll get to that question maybe last. I found it invigorating, actually. I found it very stimulating to be presented with, two competing versions and two different sets of arguments and two different sets of facts or legal issues, and to hear the parties and to form a view on which way to go. I mean, we have an adversarial system. There is only one winner. But I need to sleep at night as well. So it was very important for me to be thoroughly prepared, to be able to engage with the parties who appeared before me, and to put my questions or my issues to the parties. And at the end of the day, if it was a complicated matter, I would reserve judgment, and I would take that file away and work on it maybe during recess or another period, and write the judgment. When I was in a position to give an extempore judgment, I would, but that was less so. So yes, invigorating. I quite enjoyed also going to Durban and getting a sense of some of the issues there. I went to Quebec twice. I got a sense of the different courts. Okay. And yeah, did it impact on my social life? A little bit, but it was fine. I like writing, and I like writing judgments, so I didn't mind, quite frankly.
I was going to ask you about traveling, but it seems like you have no problems in traveling.
No, I have no problems in traveling.
Have you conducted any cases through the virtual court?
No, I haven't.
No. And what is your view about the use of the virtual court?
Sorry, do you mean about the virtual court that we have now, or are you talking about running a case like during COVID?
Well, probably like running the case during COVID.
Okay.
Virtual is basically doing the case through the electronic distance,
yes.
electronic format.
Yes. Chief Justice, yes, I have. I ran a trial about the fairness of a large-scale retrenchment. And that happened during the COVID period, and yes, we did it online. Have I, in relation to the new system in the Labour Court, the courts online, which began, I think, around about August 2020, August last year, Judge President? No, I haven't needed to. So my experience has largely been during the COVID period where, I represented a party and we did it online, yeah. Okay.
And finally from my side is, you've referred us to two judgments that are published from your side, and one of them, the very first one, that NUPSO versus the CCMA, that's a DISCAM case.
Yes.
Does refresh your memory?
Yes.
Now, that case, as I understand, you were dealing with the issue of firstly, let me check. Has that case gone on leave to appeal? Has it been appealed?
I think it's already been argued, but there hasn't been a decision yet.
On the appeal.
Yes, on the appeal, yes.
And you said that you've gone back to your judgments and looked at them. Have you looked at the judgment again and looked at how you articulated the principles and how you dealt with the application of the facts onto those principles, the legal principles?
Yes, I have.
And you're satisfied that you've covered the law and the facts in the manner that you would ordinarily do?
Yes, I am.
Okay. It's actually a case dealing with the common purpose principle.
Yes.
And as I understand, those workers, they was on a legal strike. They traveled in a bus. They started singing in the bus, and as soon as they left the bus, others started committing unlawful conduct. But the others just didn't join in. They kept just singing. And you saying, in as far as that's concerned, it fit quite well into how you concluded on that. Was it the two employees who were finally found not guilty of misconduct by the commissioner?
Yes, perhaps I can comment. Your question is kind of veering towards the common purpose. The two employees, those were a little bit tangential to the main case, and what I had to consider, Judge President, looking at Marley Pipe and the decision there, and basically the legal principle is that misconduct might be carried out by employees during a strike. Does that misconduct then flow to other employees who are not misconducting themselves? They are, in a way, the bystanders. They're just watching. Can the misconduct of the employees who are, maybe burning tires or stopping traffic or whatever it might be, can that misconduct be imputed to employees who are just watching, basically? And the legal answer is no, they can't. And that was the situation of the employees on the bus. About 70 or 80, maybe 50, I can't remember exactly the numbers, stayed on the bus whilst the majority of union members got off the bus and basically ransacked Dis-Chem at Sunning Hill and at Woodmead. And the question then became, and so the dismissal in relation to those employees was clear. There was nothing controversial about that. But what about the employees on the bus who did not get off the bus and commit misconduct? And I found that the dismissal in relation to those employees should still stand. And the reason, Judge President, was that they had transgressed 2 court orders. So the one court order was in relation to picketing rules, and the second court order was an interdict to prevent employees from associating, from gathering, from continuing with protest action. So although the nuance of that case, Judge President, the nuance of that case was, it is true, those employees who sat on the bus and didn't get off the bus and didn't commit misconduct was distinguishable from those who did. However, they too had transgressed and broken 2 court orders, and I therefore found that the dismissal in relation to even the workers who sat on the bus and sang struggle songs, that their dismissal was justified.
Yeah. Look, I guess what confuses me is your reasoning in paragraph 72 of the judgment. You found these employees did not participate in the unlawful conduct. That's your first finding. But then you say by singing the struggle songs, you found also that singing the struggle songs did not constitute misconduct. But then you say their action, and I quote here, you say, does indicate allegiance to misconduct. That's where I found it a bit confusing for me.
Okay. That wasn't part of my decision about whether or not their dismissal should stand. It was really just a comment that, first of all, I wanted to say that singing struggle songs doesn't mean that you pass the threshold into misconduct. You don't pass the threshold into common purpose. It is really, struggle songs are part of service delivery protests, they're part of labor protests, etc., etc. So I said, I found that even though there was sympathy, that doesn't prove allegiance with what had transpired. But the rationale for why their dismissal should stand was the breach of 2 court orders.
Good order. Thank you.
And that turned it for me.
Thank you very much. Thank you,
you.
Chief Justice.
Thank you, JP. Okay, net colleagues first if they have any questions. Okay, Commissioner Marumahai followed by Commissioner Mangena.
Thank you very much, CJ. Good afternoon.
Good afternoon, Commissioner.
I just want to follow up on the judgment that the JP has just taken you through. But mine is it's quite a sort of a different angle. And obviously it appears on page 45 of your pack. There were about 2,500 employees who went on strike, and about 800 employees were dismissed. Now, as I understand the judgment, there were 3 issues that you had to deal with. The first 2 one, including the parity, let's put it aside and deal with the common purpose issue. And in your judgment, you correctly rely on the dicta of the Constitutional Court in Dludlu, where Matlanga J set out what should be understood, I guess, as a test for common purpose in the context of labor law.
Yeah.
And in the context of dismissals.
Yeah.
What I don't kind of like understand in the application of common purpose, because it appears as if the test of common purpose in labor law is different from how we understand it in criminal law, the way it has been set out. So now you have just said that there were 50 or so employees in the bars. And when you apply the test, those employees were not associating in the misconduct, hence they could be excluded. But what I want to understand is if you have a group of employees, the way in which you apply this test, as it is set out, are you looking at employees individually, or are you looking at employees as a group? In other words, you are saying the group of employees on the bus, or is it every single employee to look at their actual conduct in relation to the alleged misconduct to justify whether or not the dismissal was fair? What is the actual application of this test?
Yeah, I think when it comes to common purpose, you have to individually associate. So you must, in order to be brought within the rubric of the misconduct. It's not just a nameless, faceless group. One has to look at individual association with the misconduct. And that makes things very onerous for employers, but that's the way it is. That's the law as it stands. You have to be in order to impute misconduct, you have to be able to show the evidence that demonstrates that that particular employee associated with the primary misconduct that was happening. So I think that's the test. In relation to the employees on the bus, my point was they didn't associate. They didn't associate. That singing struggle songs is not an indication of association. maybe it's an indication of support and comradely support, but it's not an indication. It doesn't satisfy the test of association. So I did not find that those employees who stayed on the bus and sang struggle songs, that they had crossed the threshold into association with the employees who had misconducted themselves. So then you might ask the question, well, why did I, despite that finding, decide to uphold the CCMA Commissioner's ruling on the fairness of the dismissal? And I did so because they had breached 2 court orders. They weren't supposed to be on the bus at all. None of the employees, they were interdicted from assembly, from gatherings and continuing with strike protest action. They had been interdicted from doing that. That was the 2nd court order, and the 1st court order that they had breached was a breach of the picketing rules. So on the basis of the breach of those 2 court orders, I sustained the finding that the dismissal was fair. I hope I've answered your question, Commissioner.
Can I please follow up, CJ?
Okay.
I hear what you're saying, and you are probably right. But my concern is not on the order that you made or the conclusion that you reached. Perhaps what I'm trying to debate with you on is the actual common purpose and how it should be applied. I don't even have the answer myself. I just want to get how you view this, because I'm looking at you laid out the test in paragraph 65 as laid out by the Constitutional Court, and what follows therefrom. Then you have a subheading that says application of the law to the facts, and then you revert to all the 2 other issues that you are dealing with. And that's where my concern, because I want to understand your understanding of common purpose, because when I read the judgment, it doesn't appear to me that perhaps, or it doesn't give me a sense that you applied the test as you actually quoted it. So that's where I'm trying to, and I'm not saying you are wrong, because I don't even know the answer myself. I just want to understand how common purpose should be applicable or should be applied in the context of labor law.
Commissioner, I mean, essentially what you have is primary misconduct perpetrated by, say, a group of workers during a strike. We know what it looks like. Perhaps burning of tires, barricading, rocks, etc., etc. So let me say you have a group, I'm going to call them the primary kind of workers doing the misconduct. Primary misconduct happens there. What is the situation in relation to the workers who are really just standing around and watching? Should the misconduct of those primary employees be imputed to the secondary employees, if I can just use that kind of language? The Constitutional Court says no, that it can't. That unless individuals in that secondary group show active association by maybe joining the primary group, doing what those employees are doing, unless there's active association with the misconduct that is taking place by those primary employees, those employees, the secondary employees, I'm just using that kind of label, cannot be found guilty of common purpose.
No, thank you. Thank you, CJ.
All right. Commissioner Mangan?
Thank you, Chief Justice. Good afternoon, Advocate or Ms. Norton.
Good afternoon, Commissioner.
We've been talking to advocates greater part of the morning. I'm adequately covered with regard to common purpose, but I want to check with you the application of the parity principle. You'd recall that some of the employees were actually given final written warning when others were dismissed. And in your judgment or in your order, you actually agreed with the employer that the inconsistency doesn't matter. But my issue is with your reasoning. You say that the employer was actually cannot be faulted for different sanctions because there were different chairpersons who had the internal disciplinary hearing. As I understand it, discipline is the responsibility of the employer. When employees complain about inconsistent application of discipline, they are saying that the employer imposed different sanctions for same misconduct. So it doesn't really matter at times who the chairperson was.
All right, that's a good observation. Let me explain my reasoning. So as we know with the parity principle, that like misconduct attracts like sanction. That's a notion of fairness, that if person A has committed the same misconduct as person B, they should both get the same sanction, basically. I mean, that is the idea of parity. What had happened in the strike is that there were about, 300 or so employees. 800, let's just put it like this, 800 employees were dismissed after the strike. But the number of employees who were part of the case that I had to review, about 250 workers had been dismissed. And what I understood from the record is that Dis-Chem conducted group disciplinary inquiries where there was consent by those workers to be part of a group disciplinary, and where there wasn't consent, there were individual disciplinary inquiries. And inevitably, when you have a multitude of chairpersons, you're going to get a range of sanctions that are reasonable. So you can't, because you don't have one chairperson who's hearing a case for 250 workers, there were many, many cases. And because you had different chairpersons, and sometimes, Commissioner, different extenuating circumstances, because we know when it comes to sanction, that a person's personal circumstances are also taken into account. Is this an employee of long standing? Has the employee in the past won employee of the month or whatever? There might be, from the different employees, different reasons, although they've committed the same misconduct, their personal circumstances might present mitigating and extenuating factors to encourage a chairperson to not grant the ultimate sanction of dismissal, but perhaps to grant, to impose the sanction of final written warning. So I think in a situation where you have large scale, a large number of disciplinary inquiries taking place, inevitably there are going to be some differences in terms of the sanction that is imposed. And I didn't find that having those differences really detracted from the principle, from the parity principle. It was a consequence of the large number, and perhaps the personal circumstances that were presented to the chairperson, who arrived at a finding not of a dismissal. And I think it only happened in relation to 2 employees, but a final written warning. And that I thought I was sufficiently satisfied because of the flexibility that had been applied.
Thank you, Ms. Norton. Coming back to the unfortunate incident in the law firm regarding the loss of trust funds, you responded to the LSSA comment where you sought to explain yourself sufficiently in terms of what happened in the law firm. In that response, you say that Mr. Mkhabela was informed in December 2014 about the misappropriation of the trust funds. You recall that part?
Yes, I do.
And then the firm, you self-reported through Mr. Mkhabela to the then Law Society of the Northern Provinces on the 30th of August 2017. There was a lapse of about 2 years, 2015, or 3 years, so to speak. A lapse of about 3 years in getting this matter reported to the Law Society. Why was that so?
It shouldn't have been. We shouldn't have waited 3 years. That was an error of judgment. But we delayed because the aberrant director was trying to recover the funds and the client, who had been prejudiced by the theft, was prepared to give him that leeway. But when it became really apparent that he couldn't fill that hole in the trust account, we then approached the Law Society, and in fact one of the charges, Commissioner, related precisely to the delay that you're talking about, and we pleaded guilty.
In 2015, did you get the Fidelity Fund certificate?
Yes, we did.
While there was still a trust shortfall?
Yes, we did.
In 2016, you got a Fidelity Fund certificate while there was still a shortfall?
Yes.
And you got the Fidelity Fund certificate out of the representations that you made that your trust account was in order when you knew that it was not in order?
Commissioner, remember we took out a loan and we filled the trust account.
Yeah, but when did you take the loan?
When did we take out the loan? Gosh, Commissioner, honestly, I really can't recall when we took out the loan, but we knew that deficit had to be covered. And we took out a loan, Standard Bank, and that's how we dealt with it.
Ms. Norton, on the 30th of August, when you reported to the Law Society, as at that time, you were reporting because the trust account was still in deficit.
Yeah, Commissioner, I honestly can't recall when we took out the loan, but we did. We filled the gap, and as I say, we were charged by the Law Society. We pleaded guilty, and that was that was the way we dealt with it. Could we have done it better another time round? Hopefully there'll never be another time around. But that's how we dealt with it.
So the 2 years that you did not report it, you had hoped that the aberrant director would make good the loss, and you would have kept quiet about this misappropriation had he paid.
Look, it never got to that sort of situation, and you know, we dealt with it as we could. You know, it's a regrettable part of my professional life. I really can't take it much further, I'm afraid, Commissioner. The disclosures have been made, and yeah, that's where we
Commissioner
are.
Baloyi, is it a follow-up question because your hand was up first?
Yes, it's a follow-up.
Commissioner Baloyi, followed by Minister, followed by Commissioner.
Also
Baloyi.
follow up here?
Yes.
Yeah.
Oh.
I know we're at the squatter camp.
Good afternoon, Ms. Norton.
Good afternoon. Is that Ms. Baloyi?
Yes, it
Commissioner
is.
Baloyi?
Yes, it is.
Yes. Hi.
The real problem that Commissioner Mangena is raising with you is that in 2014, the firm, and therefore you become aware, you're part of the people that become aware of this transgression and the shortage in the trust fund, and then you do nothing about it but hope and allow the offender the opportunity to fill the gap, and you don't comply with the law that requires you to report. Now, that is a big thing. You sat back, you did nothing, even though the law is clear. It required you to report it. You did not, and that is a problem that is being raised with you.
Yeah. Commissioner, I appreciate it. And, you know, it was not the right thing to do. It was the wrong thing to do. We should have reported it right there and then. And I regret that we didn't do so. Yeah, I can't take it much further. Yes, we were wrong not to report immediately. Yeah, I take your point.
You would accept, therefore, that it is fair, what he puts to you, that you were hoping not to be found out. And it is only when it became unavoidable, when you had to submit a report, a qualified audit report, which reflected money still owing, that the matter then got reported. But otherwise, if this errant director had been able to raise the 17 million rand in the first month, this would have been a matter buried, and no one would be any wiser but for the client and the firm. It's a fair conclusion or proposition to make to you. You have to accept that.
Yeah, Commissioner Baloyi, I do accept that. I do accept that.
Thank you, CJ.
Okay.
Okay, Commissioners, so many follow-up questions. I just want you to consider carefully if it's really necessary to put those follow-up questions following the concession just made by the candidate. Minister?
No, thank you very much, CJ. Good afternoon, Advocate Norton. I think for me it's ethical issues that comes through. One, following what has been raised with you of the 2 years lapse, but two, having disclosed in the form about this matter, but still you are appearing unprepared. I'm going to say, I don't think you are appearing unprepared, because in the manner that you are answering questions, almost contradictory, to me says that you are not yet have really processed this matter in what you are wanting us to believe, and having accepted the wrongfulness of this activity and action. And that's what I'm saying is ethical issues, because if I were you, for example, I find myself here and I'm coming for this interview, I would have had a detailed explanation, knowing the times, the years, the amounts and all that, and not having to say, I can't remember, I'm not so sure. If I understood that the position of being a judge requires high ethical standard, and therefore I would have to pass that standard here by clearing the matter that had happened in 2019. What do you have to say by these discrepancies and your lack of information and your lack of inconsistency, or even answering some of the pertinent questions that are coming with the dates, with the amounts that are being looked for, so that we can have the benefit of the doubt and trust you that this has been a lesson, as you say, and going forward it will not repeat itself.
Yeah. Minister, when challenged by the Law Society, I did prepare a 2 or 3 page response which set out the various dates, and I identified people. I didn't want to identify people, quite frankly. But I made a full disclosure. It is something I regret, and the firm, to the extent it could, it made good. It made good by admitting guilt to the Law Society. We made good by paying the fine. We made good by personally taking out a large loan from a bank to cover that deficit. We made good by pursuing criminal charges against the aberrant director. And I, there was, I'm not quite sure what else we could have done. And obviously internally we had a look at our financial systems and ways in which those could be, improved so with respect, Minister, I accept the chastisement, and I don't think it necessarily detracts from my integrity. This was a crisis in an emerging firm that we tried as best as we could to manage, which we did, and I take the criticism about us not disclosing at that particular time. And yes, we did hope that this aberrant director would make good on what he had stolen. But when it became clear that he wasn't going to, we did the right thing. Minister, I don't think I can take it much further. I'm not unprepared. I'm very prepared, and I did go through the various dates. I put them in the letter. I can't really take the matter much further. It's really here.
What do you mean you didn't want to identify anybody?
Well, Chief Justice, I didn't want to mention the name of the aberrant director.
Why not?
Why not? Because, I don't know, I don't know why. Protect his dignity. I don't know why. So in the initial response in the questionnaire, I wrote more generally. But when the Law Society requested greater explanation, I put the names.
Commissioner Matolo Dlebo.
Thank you, CJ. I'll let it pass. Thank you.
Commissioner Malema.
No, I just want to ask, for you to get the Fidelity Fund certificate, what is required?
An audited report.
No, for you to get, for the trust to get the Fidelity Fund certificate, what do you do? What do you submit to who?
You submit your auditor's report, which goes to the Law Society.
Thank you. So it means you knew about this in 2014, 2015, 2016. You say to the Fidelity Fund, the people who issue a fidelity fund certificate, our books are in order. So in a way, you deliberately misled those people. Leave the fact that the funds were stolen and all of that, you reported that, you regretted that. What about this misrepresentation before the body that gives you fidelity fund certificate? Because there is no way you had told them this truth that you said you told the Law Society. Otherwise, they were not going to give you, I suspect, the fidelity fund certificate. And after that, all these years, you remember that 2016, he asked you, 2016, did you get fidelity certificate? You say yes. 2017, did you get, 2016, did you get a fidelity fund certificate? You say yes. When did you get the loan? That one I don't remember. You remember the things that have got nothing to do with you, but the one that has got to do with you, which is a loan. Not a certificate, because you don't issue certificates. But those ones you remember. But as in when did we get the money so that we qualify to get the fidelity fund certificate, you don't remember. And I agree with you. You came prepared. You are prepared. You just prepared to come and distort this fact because you knew it's going to rise. It's not a fact that we're not going to raise it. You knew. And one of the facts that you're going to deal with is when did you get the loan? So you know if you give us the date of the loan, it's going to contradict the financial year of 2015, 2016 where you got the fidelity fund certificate. Am I correct in my observation?
Commissioner, I can't take the facts much further than I have explained and that I've written.
Justice, can I just add something to that as well? And I'm sorry to do this because I know we're out of time.
Okay.
But I need to put this to you, Ms. Norton, because for me it's a matter of serious concern.
Okay.
In your answer to Commissioner Mangena, when he asked you about the 2016 and 2015 certificate, Fidelity Fund certificate, your answer was, but we had gotten a loan to repay.
Yeah.
Right? But in your letter, you make it very clear in item 10 of your letter that in November 2017, a legal official from the Law Society had found that there's a deficit of over 11 million rand in the trust account, which means it makes it very clear that whatever loan was procured was done after November 2017. So I have to raise with you that I've got serious concerns about the answer you gave.
The logic of that, I would agree,
CJ,
stands.
CJ, my point is very simple. There are two wrongs you have done. A person stole the money, you didn't report it, and ultimately you went to plead guilty about that specific issue, which you say, that I admit. I want you to admit to the second issue, that you deliberately misrepresented the facts in order to get a fertility fund certificate, which is a separate misconduct on its own. That you cannot misrepresent the funds of the trust, even when you know there is a deficit, you cook books and then you get the certificate. That only, and this, the Law Society didn't deal with it. It dealt with you not reporting the stolen money. What about the fact that we just established now that leave the money being stolen, even the books were not properly recorded and there was misrepresentation. That's why they got Fidelity Fund certificate throughout, even when they had a deficit. Am I right?
Yeah.
Thank you, CJ.
Commissioner Bredenbach.
Thank you, Chief Justice. Good afternoon. I'm over here.
Oh, yes.
What happened to Mr., how do you pronounce his name, Adekeye?
Yeah, so there's a criminal case against Mr. Adekaya.
It's 2025.
I know.
Surely it's finalized.
I know, it hasn't. It's at the Palm Ridge Magistrates Court. It has been ongoing for about 4 years or so. And the criminal, he was struck off the roll. Okay.
Yes, in 2019.
Yeah.
When did you lay the charges?
In around about the same time, when all these disclosures were made, we laid criminal charges against him, but the case has taken a long time. It's still ongoing.
And if he had repaid the money, would you have laid criminal charges?
Um,
Try hard to give a decent answer.
no. We probably would have. We probably would have.
Probably is going to sink you. Thank you. What? You missed that?
I think Commissioner Breitenbach is finished. Commissioner Breitenbach, do you know what happened to Mr. Adike? You should know.
I don't. I'm not a prosecutor and I haven't been since 2013. But you can be sure that I will now go and find out.
I just have one point, Ms. Norton. I mean, look, I hear what all of the commissioners have put to you, but not to detract from them. But I have a narrower problem, which is that you've been drip-feeding us the disclosures, which is fully within your control. I understand the others that it was a partnership and you guys were also a victim of crime. But the problem is that your disclosures to us as the commission, have been coming in drips and drabs. This is the problem I have about being drip-fed information. I happen to sit in the objections committee and we read through these objections. If it had not been for the Law Society, the sort of mundane disclosures you made would not have made me worried. But it's because the Law Society dragged the information out of you that I actually got to know that this is a very, very big thing that we are dealing with. So I just thought maybe you want to comment about why you have been drip-feeding the commission with your disclosures.
Commissioner, I didn't feel that I was drip-feeding. In the questionnaire, I made the disclosure. I gave some background to it. Quite frankly, I didn't know how much detail to provide. And when the Law Society came back, they said there hasn't been sufficient information or disclosure, I went back into our records and I provided what I thought would be a sufficient disclosure. Gosh, if it feels drip feeding, that's certainly not my intention. I think a matter like this also creates a lot of interest and a lot of curiosity. But I don't think I was drip feeding. I made the key disclosures and the key apologies. I can't really take it much further than that.
No, I understand. Thank you.
Thank you.
Even that, I have some difficulties just on us. I just felt I was being misled, or I was not being told the full story, and it frustrated me. Because even the story about when exactly you reported Mr. Adike, the crime happened in 2014. And my understanding is that he was not reported at least until 2017. Now, that for me is a big problem. That you are a victim of crime, someone has stolen 17 million rands of a client's money, you are bargaining with them. But that disclosure, was also not pertinently made, that there was a delay in the reporting of the crime. So it's emerging now with Commissioner Malema, Commissioner Breitenbach, and Commissioner Mangen. This is the drip feeding I'm complaining about.
Look, I mean, we managed the situation as best as we could. I'm
No, don't misunderstand me. I'm not complaining about what happened at the firm.
I
understand you are a victim of crime. I'm talking about things you are in control of as an applicant to the JSC.
Well, Commissioner, if the feeling is that the disclosure wasn't sufficient, I apologize for that. I thought, I'd given the details that was appropriate. I can't really take it much further. Can I also say, this was a situation that arose many, many years ago. I'm also one of 5 directors. I certainly learned what the principle of joint and several liability meant coming out of this experience. But it has been a long time. And I have done also very, good work in pro bono clinics and done pro bono work. This is an unfortunate stain, and it really took us all by surprise.
Thank you, CJ.
Thank you.
Thank you, Ms. Norton. You're excused.
Anything further?
No,
No.
I've just excused you.
Is that enough? Okay. All right. Thank you for the opportunity, and thank you.
Shall we clear the room, please, for deliberations?